Welcome to Dali Talk. This is Dali. Oh boy, how's everybody doing today? Today was quite interesting with old Sarah. Alright, so Emily. How are you doing? This woman should have accepted the plea deal. So, yeah. It's not looking too good for our girl. But it was not intentional, so at least there's that. Hey, Scott. Half Irish, ceiling cat. So bear with me as I've never really done a show like this before. It's just me talking, and I'm going to pull up some pictures and kind of go over what happened today. But it's not a format I'm used to, so hang in there. If we get through it, we might get to the motion pretrial on Friday before the opening statements, because Hella didn't get a chance to play that yet. So, anywho, let's see, what do we have? So, the day started, first witness was Dr. Sarah Zidowich. Pull her up. So yeah, she came in. Probably should have had timestamps, maybe next time. I really liked the CZ in her name, very Polish. She talked about how he died. It was a combination of lack of oxygen, not complete lack, but lack of oxygen combined with positional asphyxiation. Owens did his best. You only have, the facts are what they are. So each went over other ailments or other possible ways or things that could have contributed to Jorge's decline or demise. One thing he noted was that Jorge had a condition in his heart that basically is a heart attack waiting to happen. Well, okay, but you can tell if there's a heart attack, and he didn't have a heart attack. Let's see. So I'm just going over my notes here. This here is the height, 62 inches, so like 5'2", weighed 103 pounds. They showed some of the marks on the body. He had a lot of marks that really we didn't know about before. Hey, Laura. Sarah's insane in my opinion. I wish she had a tiny bit of remorse, but she doesn't. No. I'm all for her having a fair trial, but she doesn't seem to appreciate the gravity of things. So if he didn't die from the lack of air, and Scott was really helpful today. Thank you for all those notes and everything. Owens was trying to argue that she would have found he died from a heart attack. Yeah. And it's worth a shot. I mean, it is what it is. Hey, Ian. Did the autopsy report state what kills me is that the victim was begging Sarah to let him out. He was tall and the suitcase was really small. He died of positional asphyxiation, basically. It wasn't like they couldn't really measure how much oxygen could go in or out, but we're gonna, when I redirect you over in like 50 minutes over to Hella, she'll be doing a quick go through of the day today without breaks and everything. Not anymore, for God's sakes. I removed it. Hey, Hella. So, well, okay, so on this, I wonder, do I have a highlighter? We'll get better at this, guys. I'm sorry. No, not really. Okay, so, oh, there we go. Here is a bruise on his arm. And then there's that interesting tattoo there. He had some bruises on his body, more than we thought. Like before, they didn't really say, it was just like his hand. We can see this one here. There's another mark. It's looking like, yeah, they only showed a few photos. But it's looking like Jorge was hit a few times with a bat. So, most of his upper arm, yeah. So, I'm wondering, how much was he incapacitated to get into the suitcase? There's some doubt she had to teach him a lesson. Yeah. There's some other really weird, we learned some stuff that we didn't really know. It was all like, oh, she did it for hide and seek. But maybe that could be a bit of a fib. What is that part of the body? I believe that's his arm, or upper arm. So, the Owens, made a big deal about him drinking. Maybe the alcohol had something to do with it. That's a bruise. That one. Owens tried to impeach her that there was only the Emmy had only done 5 positional asphyxiation cases before. So I hadn't seen him that much, but she seemed to really know what she was talking about. Let's see. Let's see. So his blood alcohol was 0.213, I believe, or no. Sorry, guys. Oh, at the time of death, it was 0.139. So it could have come down from then. It isn't common, yeah. Hold on, guys. Excuse me. Let's see. So after the Polish girl, the Emmy, they stipulated some stuff. Victim ID, George identified, self-defense stuff. Basically just the basics. She did play that suitcase game with her ex and kid also. She tricked him into the suitcase. Well, there was a photo of her. It was more her ex kind of like jokingly shutting the zipper on the kid. Kind of, the kid was still out, and they took a photo. That seemed kind of harmless, unless there's something else. Maybe she tricked him into the suitcase, or yeah, I could see her just beating the suitcase. It's weird. But we haven't seen any of the BSS evidence yet. That's here. The big thing today is that the lead detective takes a stand at the end of the day. Well, we'll get to that. And we'll give you an update on the what's left for the state's case. Now, next we got Meredith McCaskill. She was the Florida Department of Law Enforcement. She did the report of, she's in like the crime laboratory analyst. Just basic stuff you need to get on the record. Next one. That one was kind of uneventful. This one was kind of important because she did the forensic examination of Sarah's phone. And what does that mean? That means that she can validate the videos on the phone. So we got to see the suitcase video as well as some text messages. One thing that's still a little confusing at the moment. Let's see. So there's some sus texts. Here. What's interesting is she's using the cell phone, either using the actual cell phone or the email address of Brian Boone, her ex. So it's coming across with his name on it. And she's saying stuff like, "Ugh, your dad hit me in the face." And I believe that was to one of Jorge's brothers. Correct me if I'm mistaken. But she's here. Yeah, she was. I watched this witness. I thought she was good. Yeah. She talks about hide and seek here. This was like 2 months before the incident. She's definitely got a thing for hiding and seeking. But she's either Brian Boone pays for her cell phone, which is a distinct possibility, but it's just very weird. So we got the text messages in, data, things like that. Thank you, Scott. The text was to Moses, Jorge's brother. Okay. Oh, boy. So Shelby was looking cute today, as usual. Wore her hair up. So at this time, we go to lunch. And we find out that the next witness they're going to call is Capsic. And oh, okay, Scott. Yeah, you're right. This is the famous fight where Moises beats the crap out of Jorge. So what was I saying? They go to lunch, but before they do, they discuss what's next. So they're calling Capsic next. They played the body cam, and then they're playing the whole interrogation. So like 5 hours. And then like 40 minutes of questions. And then it looks like they're going to rest either probably tomorrow morning, because I don't think they're going to finish today. So what does that mean? That means we more than likely are going to get the Sarah Boone taking the stand tomorrow. Our girl Boone is going to take the stand tomorrow. They are moving very fast, but basically Owens is in a really tough spot right now because he has to have Boone testify to get the BSS in. And then he's going to probably, I assume, call back a lot of the witnesses because he really didn't cross them. I expect the ex-husband, Brian, to be called back, and that could be spicy. But I would imagine so. I mean, just the fact that Brian's like in the Celebrite report is odd. Lefty. Yeah. I mean, I really did give Sarah the benefit of the doubt somewhat, trying to, like, we'll wait for trial. Maybe, I mean, she's guilty, obviously, but maybe it's not murder 2, it's just manslaughter. I don't know. Today just was not a very good day. Let's see what else. Apparently, Judge Kraynick did not like Sarah Boone looking back at the gallery so much. I guess to talk to members of her legal team. During lunch, Owens had to kind of rush around to get some CDs because they didn't want jump drives for the jury exhibits. Okay, so we come back from lunch. And here we have, this part's kind of funny. It wasn't captured on audio because it was on mute mostly. Maybe a couple words. But basically what happened is a woman in the courtroom walks in and yells, "Is this the Sarah Boone trial?" And then when the deputy brought Sarah Boone in after a lunch break, the woman said, "Deputy, you should be fired." Sarah asked the deputy who the woman was and then kind of smirked. The judge basically kicked her out. And another person that was in there, Jules. Yes, Brian is the ex. When the judge asked the woman to leave, she started preaching in the courtroom. So then the judge went on kind of a long rant about, courtroom decorum. Okay. So we got Copsol. I don't think it was captured on video. Was it? Do you know how much of it was heard? Okay, cool. I'll pull it up. So this is the Capsule, the lead detective. Hold on one sec, guys. Well, okay. No, I don't. Sorry, guys. Bear with me here. I'm trying to see if I can find the video. So, is it still going today? Jeez. Okay, I found it, I think. No. I know it's a lot easier when you don't have timestamps. Ah. Right, when you just do pictures. Well, let's see what it does. Probably should help if I share it.
We are back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
APS Story on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
All right, Mr. Beck is not with us. Okay. Ms. Boone is still seated at counsel's table, wearing the same clothing that she had on this morning. She is in custody, however, out of any restraints. So we will be standing when our jury enters and exits. It's 2:04. State, are you ready to proceed? Yes.
Maybe they kicked her out after this. Come on. It's after this. Thank you so much, Scott. Is that the white noise on? Come on. Really? Sorry, guys. Come on. Come on.
Issue.
Okay, here.
All right, thank you all for letting me know the lay of the land with regard to those specific issues. We're going to bring our jury in momentarily and inquire to staying after 5 o'clock. Members of the gallery, good afternoon. The state is going to continue with their evidence presentation. I know this morning some cell phones were going off, or there was chattering in some cell phones this morning. I'm going to please respectfully request that you turn off your cell phones and not have any correspondence or communications orally amongst yourselves or anyone else in the gallery. I'm not going to allow any outbursts. If you cannot contain yourself, I'm going to ask you now to remove yourself. This is your one and only opportunity. If you cannot control yourself or there are outbursts, I will ask the courtroom deputy to remove you. Does anyone have any questions with regard to the court's instructions? If you're wearing sunglasses, I need you to remove them. Thank you. All right, with that, state anything we need to address before we bring in our panel.
One more thing.
Yes, sir.
May we approach?
Yes.
I guess I missed it. Well. Rest of the day was just the Stevie Wonder would have to remove his glasses. Yeah. It was just the interrogation mainly, and that's still going right now. But we did miss. I can keep going, maybe. Come on. You can do it.
Let's
see.
All right. Thank you all for your patience. Ma'am in the back left, last row. Good afternoon. After conversing with the state and the defense, they've agreed and asked me to excuse you from this room. I understand that there may have been an outburst by you with courtroom personnel before the judge arrived on the bench this afternoon. If you would like to watch the trial, it is being streamed live. You can head to the 12th floor, get off the elevator, and head to the south side of the building. See the sign where it says Judge Michael Kranick, and it'll tell you which direction to go. You can pick up the phone, call my judicial assistant, Anita Barrios, and she can give you instructions on how to watch this trial virtually, okay?
Okay, thank you so much.
Thank you, ma'am.
Go ahead, like doing it anyway. Okay, God bless you guys. I'm still the boss of the city, so we gotta work together and try to figure it out.
Thank you, ma'am.
And y'all heard what I said. Ms. Jones, you're fired. Have a good one.
Thank you. To restate the court's prior positions, if there's anyone going to have any outbursts or cannot control themselves, again.
Wow. Okay, so it was, some of that was, I rebuke you, lady. Judge kicked somebody out of the courtroom, and because she was having several outbursts. So that was interesting. I wonder who she was. That is funny. Okay. Now, let's see, I had, crap, did I?
Item 2 of the
So, yes, it was a narcissist. So I thought I would do one thing from before opening that Hella didn't get to. The motions before opening. Because I thought it was kind of interesting.
Defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68.
Well, I agree with the state attorney. I did follow up. Well, I agree with the state.
So this is where Owens really wanted to bring in his poster board. He likes his posters.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did follow up on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon considering the verdict. You want to read it out?
No, I can see it, sir.
The other one is a reasonable doubt is not a possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge, opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law, we'll both have an opportunity to use the actual jury instructions, which we have not decided upon.
Yeah.
We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in the circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
And there's a small issue here.
Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction.
I mean, it sounds like he's used this for years and just brings it whenever he does opening. Unfortunately, the Supreme Court changed the wording this year. And he didn't get his little things updated in time. Didn't have a chance to go to Kinko's and get a new poster board printed. Whoopsie.
For those reasons,
When those law students are like back there like, I'm
not going to allow it.
Judge, I'll have it redone in arguments.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
Give me a moment.
I don't know what it is with Florida and the word vacillate. Comes into every trial there. Sarah could do a new poster for him.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Yeah, they changed the wording of it this year. I think he can explain it, just not like with the poster board, since it wasn't correct. What are we doing here?
Photograph, close up of Sarah Boone after she was kicked in the head by George Moore. Lift it to the eye. There's another close up of Sarah Boone's face after she suffered injury at the hand of George Moore. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had photographs. The state provided the defense in discovery of these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the long-size pages of the photograph, and then using these as the most to show the jurors their opening and then closing the injuries that Sarah Boone sustained at the end of George Moore.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens.
Yes, Sir Judge, I sent you some case law.
When did you send it, sir?
This one.
I have not received it.
I think you were already on the bench.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
It's just these two cases. Been provided at Alsager v. State, 326 Southern 3rd, 656, Florida Supreme Court 2021, Low v. State, 259 Southern 3rd, 23, Florida Supreme Court 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy that we're using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be. State wanted to introduce a dummy that we're using in a homicide case, which the court allowed. Other.
I know that trial, George Zimmerman. That was the George Zimmerman trial. And the state comes in there and uses the mannequin or the dummy and tries to like drive a rod through it to show the path of the bullet. Well, when they went down, the medical examiner was on the stand, and the defense waits for the prosecutor to put his mannequin all the way into the back of the courtroom, gets up, asks the prosecutor to borrow his doll, proceeds to throw the doll on the ground and just bash the head in while periodically asking the medical examiner, does this seem like a life-threatening wound? And then just beats the crap out of the doll. That was... Judge wasn't very happy.
Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Al-Qagir case, which is a 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record.
Oh, hello.
Wow, you're actually in decent software.
Oh, whatever.
Like, it's simple and it works. Hi.
Hi. How are you?
I'm good. I was just going to ask you what the best stream was today.
For quality? Probably Trial TV
Okay. Cool.
or Fox
All right, keep
35. Yeah.
Thank you.
Yeah. I'm just, finishing this.
Yep, sweet.
The 2018 case, Supreme Court of Florida. Again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense, and part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the law. I think the two instructions would read, find that Sarah Boone, who because of prior threats or difficulties with Jorge Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands
It's a
of the court.
shit
You may consider this
version of
fact
whatever
to determine whether
software
the
you're
action
talking
is
about. I don't
of
know.
the original person.
Just come back here. For good. It's just so much better here.
As long as you find at the time of the alleged
comfortable
second-degree
is
murder,
it?
Sarah Boone knew that Jorge Torres had committed
It's
an act
nice.
or acts of violence. You may consider that
It
fact
works.
as being Sarah Boone reasonably
Come
believed
back
it's
here.
necessary for her to use the number. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. We can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all
Let's
coming.
go.
So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that?
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing,
Bring back Wade.
I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence. It's a standard instruction.
But the overt act requirement remains. We've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act. That she was facing imminent threat.
He's Florida man.
Oh no.
Yeah.
What have we started?
Understood. Your response to Exhibit B?
Look at which one's B.
It's her on the back porch with the two dogs.
Judge, not only did he...
What's the same with Sarah? There are 300
That's not
Sarah
the issue.
channels.
The issue is that the state represented that it was not part of your exhibit list.
I believe it is part of the exhibit list. We got this.
As of next week, there'll be no more Sarah on my
They sent over
channel.
a bunch of pictures
Done.
of flowers or paintings that they want introduced.
My channel
They
anyway. What about
listed as
you?
exhibits.
You gonna keep
I
flogging
thought sure we
Sarah?
put this on there, but the relevance of it
Hey,
is not only did he abuse
Hey, some of us still play Amber Heard, so
Some people still play Amber Heard, and that was nearly 3 years ago.
it's been.
We're not going to
88
mention who.
years.
Yeah, they're still making Megapint jokes. So Half Irish. No. Okay, so Half Irish says, I blanked out a minute. Now it's self-defense, not BSS. They're the same thing, right? So I know it's confusing. So self-defense, battered spouse syndrome is a self-defense argument. So if you read up on it, it's part of it. So the person who experienced the battered spouse syndrome then acted out in self-defense because they were in a series or a long-term built-up period of being battered. And then one day something happened, and because of that long-term series of domestic violence incidents, that led to them being more inclined to want to defend themselves, but there still had to be an overt act. So yes, it is a self-defense argument. And as Andrew Brunker said to me, or he did on that one stream that he came on, but he's also said to me in messages a few times, it is a bit of an estrogenic argument. But he loves using that term, estrogenic. I have to go, by the way.
Okay, yeah, I'm going to end right now anyway. So I'm going to redirect over to Hella.
Yep.
It's been a lot of fun, and I will see you guys over there. All right, bye.